Good morning. Good morning. I'd like to call this meeting of the House Labor and Industry Committee to order. I like to try to keep things on time, and we're already 2 minutes behind. So, yeah. So let's get started, and if we could all rise as we are able for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'd like to welcome everybody to this meeting today. It's good to see a full house here at the House Labor and Industry Committee meeting. The meeting is, of course, being recorded, so I want to remind all guests and members present to please silence your cell phones and electronic devices. And would the Secretary please call the roll? Present.
Representative Cox. Delozier. Dosh.
Here.
Gillen.
And Representative Grove entered the room after he was called on the roll. And just as a note, I've invited Representative Oberlander, who is a member of the House Republican leadership team, to join us this morning. She was in the building and stopped by, so she's joined us here with the rest of the members of the committee. Today we will be discussing a rulemaking proposal by the Department of Labor and Industry. This proposal would revise the exemption criteria for the executive, administrative, and professional exemptions from minimum wage and overtime requirements. This proposal has raised a lot of concerns from Pennsylvania employers, so I wanted to have this hearing to shine some light on this proposal and its possible impacts on a variety of different types of employers. We have our first presenters here. John, did you have anything you wanted to, I think you have an introduction, I was told this morning.
Thank you, Mr. Chairman, and thank you for the opportunity to speak. First, I need to introduce a couple people. I have a new research analyst for the committee. His name is Evan Francis. Appreciate you coming on. And also we have, we named our new executive director for the Labor and Industry Committee, and that's Haley Solera, who certainly is deserving of it. So, can I say something? Are we going to talk about the act first, or?
If you would like to speak before the secretary does, you're welcome to make any opening comments. Sure.
The only point I'd like to make is that this act, you know, it is important to hear from employers as to how this act will impact the employers, but that we're only hearing from one side. I mean, as we go through this whole day, what you're going to find is that's all we're hearing from is employers. We're not hearing from the actual employees themselves, and that was disappointing. But I am looking forward to the testimony. But as we go through this, just keep in mind, you're only going to hear one side. The employees themselves are not going to be heard from today. So thank you.
Thank you for that point. My hope is that the Secretary and the Department of Labor and Industry can effectively articulate their reasoning for bringing forth these new regulations, and so thus we've opened it up for them to start this and give their reasoning. And you know, I think most of us would like additional money in our paychecks, but it is important to discern how these new rules will impact the job creators, the folks who employ Pennsylvanians, and we're attempting to continue to make sure Pennsylvania's economy is moving forward, and our job creators are continuing to create jobs. And so that's generally the perspective and the reasoning for how we put our agenda together today. And so with that, I will open it up to our first presenter, which is our Secretary of Labor and Industry, and he's going to explain the proposal and the department's rationale. Joining him to assist with answering any technical questions is his Deputy Secretary for Safety and Labor Management Relations. Mr. Secretary, I'll let you begin. If you can just attempt to keep your oral testimony between 5 and 10 minutes so we can leave plenty of time for questions from the committee and then our second panel. Thank you, Mr. Secretary.
Good morning. Good morning, Chairman Kaufman, Chairman Galloway, and members of the House Labor and Industry Committee. I am Jerry Oleksiak, Secretary of Labor and Industry for the Commonwealth of Pennsylvania. I appreciate the opportunity to testify today on the Department of Labor and Industry's efforts to update overtime regulations under the Pennsylvania Minimum Wage Act. This proposal aims to strengthen the middle class in our Commonwealth by modernizing outdated rules to ensure workers are fairly and justly compensated for their hard work. It's appropriate that this hearing occurs during the week of Labor Day. The holiday was established over a century ago to honor the labor movement and the social and economic contributions of American workers. In the decades after its creation, workers engaged in countless struggles, many right here in Pennsylvania, to achieve fairness and equality in the workplace. New laws and labor contracts were enacted to protect employees from exploitation and abuse, and to create clear, consistent guidelines for corporations large and small. This legal framework fueled decades of economic growth and middle-class prosperity. Many of the benefits that workers enjoy today stem from that labor movement, including the 40-hour work week, the weekend, paid vacations, sick leave, minimum wage, and occupational safety and health protections. Modern workers still rely on these protections, and Labor Day is our opportunity to celebrate these accomplishments. In 2017, Governor Wolf convened the Middle Class Task Force in an effort to similarly focus our attention on working men and women. As a member of the task force, I had the opportunity to hear firsthand from workers, students, educational institutions, labor organizations, and employers. A common theme emerged during these meetings. Workers are struggling because of low or stagnant wages, preventing them from joining the middle class. Since day one, Governor Wolf has prioritized Pennsylvania's working residents and families. The work of the Middle Class Task Force reinforced this priority and bolstered our efforts to modernize workplace laws and protection for workers. Originally enacted in 1968, Pennsylvania's Minimum Wage Act begins with a declaration of policy in which the legislature stated its intention to protect employees from, quote, unreasonably low wages not fairly commensurate with the value of the services rendered, end quote. Among other things, the Act directed the Department of Labor and Industry to establish and make periodic revisions to overtime rules through regulatory action. That's what we are attempting to do with this proposed change. The regulations aim to achieve two fundamental goals. One, to modernize the badly outdated minimum salary that a salaried worker must earn to be exempt from overtime pay. And two, to simplify the duties test to improve compliance and more closely align it with federal regulations. Both changes will help the department fulfill its statutory obligations to protect workers from unpaid overtime and to maintain fair and responsible guidelines for employers. Because the overtime rules have not been updated since 1977, employees are covered by an exemption that was intended for higher wage, white-collar employees more than 40 years ago. Under the current law, the minimum annual salary threshold for the exemption is about $13,000. This amount is so low that it is beneath the current minimum wage of $15,080 annually for a full-time worker. Currently, a salaried worker earning a little less than $24,000 a year, which is below the below the poverty line for a family of four, may work unlimited hours a week without a guarantee of overtime. The current salary threshold has become functionally obsolete, unfair, and unjust, and does not in any scenario accurately describe an executive, administrative, or professional employee. In addition, the outdated protections have negatively impacted compliance and caused confusion for both employees and businesses. This proposed rule aims to simplify the duties test while more closely aligning it with federal rules. During this process, we worked to develop updated regulations that recognize the needs of both employers and workers. The rule is designed to be phased in, allowing 3 years before full compliance. More than 1,000 public comments were submitted, and I am pleased to report that more than 60% of those comments were positive. Again, we're pleased here today to receive input from one of our stakeholder groups. I should note, as we heard from Representative Galloway, that other stakeholders, namely workers and their families, should also be invited to participate in this discussion, and a number of those interested parties I know are in the audience here today. In the coming months, we plan to closely review all public comments received during the IRC process, the Independent Regulatory and Review process, and carefully consider our next steps. L&I will continue to welcome feedback from all parties affected by this proposed regulation. While everyone here today may not agree with the proposed regulation in current form, I think we can all agree that the existing threshold is not in line with economic realities and does nothing to help many of our fellow citizens break the cycle of poverty. The bottom line is that 4 decades is far too long for Pennsylvania's overtime regulations to remain stagnant. Updating the overtime rules to keep pace with our 21st century economy is simply the right thing to do. It is the right thing to do for the hardworking men and women of the Commonwealth. It will generate competitive salaries and reduce turnover for employers, helping to create and keep jobs that pay here in Pennsylvania, a benefit for employees and employers alike, as well as the communities in which they live. I thank you again for the opportunity to speak with you. Deputy Secretary Jen Berrier of the Department of Safety and Labor Management is here with me to offer more about the proposed regulation, and then we will be happy to answer any questions you may have. Thank you, Mr. Chairman.
Good morning, Chairman Kaufman and Chairman Galloway. I am Jennifer Berrier, the Deputy Secretary for Safety and Labor Management Relations. I began my career with the department 12 years ago, serving as legal counsel with the department, and I also served as legal counsel to the Bureau of Labor Law Compliance, which is the bureau responsible for administering and enforcing the Pennsylvania Minimum Wage Act. As Deputy Secretary, I have the valuable experience of previously providing guidance to the department on minimum wage and overtime issues and bringing legal action against employers for violations. Over the years, I have become very familiar with the exemptions that are the subject of this discussion and can attest firsthand that misapplication of the EAP exemptions, also known as the white-collar exemptions, is one of the most common overtime violations the department encounters. The executive, administrative, and professional exemptions relieve employers from paying minimum wage and overtime to qualifying employees. To qualify, an employee must be paid on a salary basis, and that salary must meet a threshold. And also, there's another test that the employee must meet, and that is the duties tests that are specified in the regulations. For the executive exemption, the duties relate to managing employees. For the administrative exemption, the duties are office work that directly relate to the general operations of the business, not the production, and it also relates to exercising independent judgment in that role. For the professional exemption, the duties relate to work requiring advanced knowledge or work that is original and creative in nature. It is important to understand that the original thought behind the white-collar exemptions was based on the belief that exempt workers earn salaries well above minimum wage and enjoy other privileges that set them apart from workers entitled to overtime. Exempt workers typically have above-average fringe benefits, a better bargaining position for work time and pay, and more opportunities for advancement. The white-collar exemptions were set forth in statute by the legislature and intended to be used for higher salaried employees. Over the years, the spirit behind these exemptions eroded as the salary test became outdated, deficient, and ineffective. More employers began to claim these exemptions for lower-waged employees while ignoring the duties test. Increasing the salary threshold not only helps to ensure that non-exempt workers receive minimum wage and overtime, but also helps employers to identify which workers are truly covered by the white-collar exemptions so that they can avoid costly litigation, especially since the courts have often reiterated that the Minimum Wage Act is aimed at protecting workers. It is the department's duty to reinstate the salary threshold portion of this test so that employers have clearer guidance on applying these exemptions. I've had the opportunity to review many of the public comments, and a prevailing theme was the misunderstandings concerning the white-collar exemptions. Just because a worker is paid a salary by his employer does not mean that worker qualifies for these exemptions from overtime. This appears to be a shared belief among employers and workers. The main issue highlighted by the public comments is the misclassification of workers as exempt when they do not perform either executive, administrative, or professional duties. Job titles do not determine a worker's exempt status. For example, an administrative assistant does not necessarily meet the duties test of the administrative exemption. This is a common mistake I came across in my prior life as the department's legal counsel. In fact, in most cases, administrative assistants do not customarily and regularly exercise discretion and independent judgment with respect to matters of significance to the business. The same is true for receptionists, bookkeepers, and other workers who perform clerical duties. These are just some examples that I've come across. Other common misclassifications of the white-collar exemptions include assistant managers, human services advocates, caseworkers, case managers, inspectors, LPNs, and CNAs. Again, the public comments lead me to believe that these professions are being misclassified as exempt when these workers do not meet the duties test of the exemptions. Admittedly, the department's outreach and educational materials are lacking, and that is something that the department will work on remedying. The department is considering publishing materials like those published by the Federal Department of Labor, such as fact sheets and PowerPoint presentations. It will also consider promoting this material through social media or by providing educational presentations to associations and trade groups. I recently had the privilege of meeting a longtime employee of the Federal Department of Labor's Wage and Hour Division, who frequently travels the region to provide education on minimum wage and overtime issues. And we discussed how the white-collar exemptions are commonly misapplied under the federal standard too, which is why the Federal Department of Labor attempted to raise its threshold. The threshold ensures the purpose of the white-collar exemptions is being effectuated. I ventured to ask the DOL representative about the status of their regulatory attempt to raise the threshold, and it was indicated that there's some certainty as to when the new proposal will be submitted, even though it is listed on the agenda for 2019. More recently, I found that the federal DOL is now conducting listening sessions throughout the month of September, more than a year after it requested information from the public on this issue. Pennsylvania cannot wait for the federal government to act on raising the national salary threshold for the white-collar exemptions. There is a reason that Pennsylvania enacted the Minimum Wage Act, in addition to the federal government's enactment of the Federal Fair Labor Standards Act, and that was to provide further protection to Pennsylvania's workers. Also, Pennsylvania's law was meant to cover employees and employees who are not covered under the Federal Fair Labor Standards Act. Thank you for encouraging this discussion with some of our employer stakeholder groups and bringing this important topic to the forefront. The department looks forward to reviewing constructive criticism on its proposed regulations so that it can evaluate the best possible course of action moving forward for hardworking Pennsylvanians.
Thank you very much, and we'll move on to questions and answers. And first on that list is Representative Keller.
Thank you, Mr. Chairman, and thank you for your testimony. Just one question. I know we're talking about raising a standard that was set in 1977, from what I've gotten in the testimony. And while we're evaluating this, the Department of Labor also deals with prevailing wage thresholds and so forth for projects. Is that correct? Has the Wolf administration considered increasing the threshold of projects that are exempt from prevailing wage that was set in 1963? Are there any plans to look at that also while we're looking at thresholds?
None that I'm aware of.
because that would be a huge benefit to our local municipalities and governmental entities to get more done with dollars. I would just encourage us, and maybe we can talk with the governor, that along with this, as long as we're looking at doing these things, I think it would be fair to look at the prevailing wage threshold that was set in 1963. So I hope I can get a commitment out of the Department of Labor to work with me on that too.
We're ready to work with the committee on that issue, the issue we're here about today, and any other concerns that the committee has.
Thank you.
Representative Galloway.
Thank you, Mr. Chairman. And thank you, Mr. Secretary, for being there. Thank you very much. Really appreciate the testimony. I got a question about the process. Misclassification. You know, somebody's out there, they're misclassified, and they want to file a complaint. What is the process? Where is it? Is it documented? Is there some sort of process to go through? Thank you. I appreciate it.
Sure. The department's website actually has a fillable PDF that you can directly submit on its website, and it'll be transferred to the Bureau of Labor Law Compliance. And depending on where the complainant is located, it will go to one of the Bureau's 5 district offices to be assigned to an investigator.
So, who is, you know, what happens then? It goes to a district. It goes to a district office.
Right. So it goes to a district office. It's assigned to an investigator. Then an investigator will contact the employee, find out, additional information concerning their claim. And
okay. So they will reach out to the employee.
Correct. And then after that, they will reach out to the employer and audit the employer's payroll records for the previous 2 years for all employees.
And what kind? You know. I guess there's one of 2 outcomes, right? There can only be one of 2. What happens if they are found to be misclassified? What is the enforcement?
Okay, so our enforcement's a little bit different than the Federal Fair Labor Standards Act. The Federal Fair Labor Standards Act provides for penalties and all sorts of damages, but the Pennsylvania Minimum Wage Act provides for the employees to be compensated the wages that they're due under the law. So what the Bureau does is tries to make the employee whole again.
When you say Bureau?
The Bureau of Labor Law Compliance.
And you have the authority to do that?
Yes.
Okay. All right. Thank you.
And before I move forward, I neglected to note members who had entered the room since roll call. Just wanted to make sure. Representative Cephas, Representative Delosier, and Representative Donatucci are listed on the roll. And moving on with questions, we have Representative Dush.
Thank you, Chairman. I'd first like to get some clarification. I want to use an example. I have a small town called Somerville that has about a population of 500 and some people in it. The median family household income is about $30,000 and $19,000 per capita income. They have a public library that the head librarian, as well as the people who work there otherwise, they get paid, but they put in far more hours, and mostly it's on a volunteer basis. They're there, but they know what they're going to get paid, and they're there much longer because they're devoted. It's a small town. They're devoted to make sure that those kids can have access to reading materials, as well as teaching them how to do research projects, that sort of thing. And they can't afford not to have some kind of an income with the time that they're expending, but at the same time, this type of a threshold could really seriously jeopardize them. How does the department address something like that?
If you're referring to a governmental entity, governmental entities are actually exempt under the Pennsylvania Minimum Wage Act.
This is not a. This is a free library.
This is a free library.
The borough does provide some money to them, but their library board sets the salaries. How do you prevent that library from shutting down with a rule like this?
Okay. Well, I first have some questions as to what employees are being paid salaried, because I kind of have a concern with that. But I think that the library would have to adjust its business practices. This threshold is not a mandatory threshold. So employers have many choices as to what avenue they can take or how they can adjust their business practices to account for this new regulation.
Well, my understanding is the reason that they're salaried is because they can't afford an hourly rate for what these people put in. And it's, like I said, the people stay there longer than the borough could, or that the library board could ever afford to pay them for what they're worth. They contribute far more than what they're worth, but they're doing it because they are people who care about those children and care about their community. Again, they can't afford not to have a salary or have something coming in, but by the same token, they're contributing much more. And I think this has the possibility of severely crippling, or if not shutting down, this library.
Representative, it clearly is not the intent of the changes to make that happen. And I, based on my previous life as an educator, I can certainly understand people who put in lots of extra time and do the things that they need to do for their community. What the intent of this act is to help to rebuild the middle class. We have too many employees in Pennsylvania that have not been part of the recovery that we have seen here in Pennsylvania and nationwide. It's important that, again, in the act there are a lot of different ways that businesses can look at how they can make the adjustments they need to make. It doesn't mean that if you know, somebody, there's the duties test, there's the changes, so businesses can find alternatives to how they want to conduct their business, or they can follow, you know, the letter of the recommendation. So there are options that they will have.
Well, they've been examining options for quite some time, and the role model they came up with had to do with basically what they could afford to do. And it's, you said about the intention and the law we deal with most often in this House and in this body is the law of unintended consequences. And I have a feeling that in this rush to get this thing through, there are going to be a lot of unintended consequences that could severely impact organizations like the Somerville Library.
And I would respond that there have been many unintended consequences of not changing the act in 40 years. Our middle class is struggling. Employees across the Commonwealth, many of them, particularly in lower-end salary occupations, have just not kept up, and that is the intent of the regulations.
Well, my point is I think we're in a bit of a rush here. We're 48 hours from the federal government beginning their listening sessions on how it would go. And like I said, I'm very concerned. This is one thing that, this is just one. I have a feeling there are going to be more. So I'll yield back to the chairman.
Thank you. Representative Nielsen.
Thank you, Mr. Chairman. Madam Secretary, thank you for pointing out about the titles given to people don't actually explain what they actually duties are. In today's world, these kids come out of colleges and all of a sudden they're a vice president of this. And I said, well, what do you do? He says, oh, I'm just selling for him. He sends me out to this. I'm like, you're a vice president? And he says, yes, we give it all. And this way, they're on that salary. As far as rushing, I want to point out, it's been 4 decades. It's been 40 years. I don't think we're rushing anything. I think we actually drug our feet on this. But since we're being recorded, Mr. Secretary, maybe you can let the public know, because I didn't think we actually spelled out the process of this rule changes. Because I don't think anybody ever addressed that. And if this being on TV, if someone watches it, they'll just think, hey, okay, here we go. We're passing another thing here. There's a process that you have to go through to change these regulations. Maybe one of the two of you can explain that. The process that we're going through now. We talked about the thousands of letters that you received and 60% were in favor and stuff like that. Just the overall process, if you could. And the chairman, since we started a couple minutes late, Chairman, that's all I'm going to ask here.
Thank you, Representative Nielsen. This actually, we began receiving input on these regulations at our minimum wage advisory board. Since this is part of the Minimum Wage Act, it was discussed there. That's a board made up of employees, employers, labor, business, citizens, and they provided input on it. It then went to, we also received input, as I mentioned before, the governor's middle class task force. that was composed of leaders of labor, business, higher ed, and several cabinet members. And we toured around the state as part of that middle class task force, at least 8 different areas of the state. Maybe there are a few that I missed, so there may have been more, getting input from citizens in those communities about the concerns they had. And one of the concerns that came up often was minimum wage. And, there's an obvious connection here with the overtime. We then submitted the regulations to the, based on those input that we had and conversations at the department. They were submitted to open and available for public comment. And that's where we received over 1,000 public comments, and as you mentioned, 60% positive. The next step is they will go to IRC for the independent regulatory review, and based on that, we'll look again at what we hear from IRC, see if there's any adjustments we need to make, and open it up to hear from other folks. And we have opportunities like this hearing, where we will be hearing later on from employers. So it has been I agree, it has not been a process that we have rushed into. The comment period was extended from 30 days to 60 days. There was some requests to go to 90 days, but the IRC has never gone beyond 60 days, and that's where it was capped. So we did extend the comment period. So I think we've done all we need to do thus far to get the public comment that we feel is necessary.
Thank you very much, Representative Klunk.
Thank you, Mr. Chairman, and thank you for joining us today. First, quick question to follow up on Representative Nielsen. He had mentioned about the 60% of letters were in favor of it. Do you know how many of those letters were from government employees, so state, federal, local employees, municipal employees? Because it's my understanding, this regulation wouldn't impact them. So, their comments, while important, it wouldn't directly impact them and their work and their paycheck.
Actually, to my knowledge, we haven't received any public comments from public employees, but we have received public comments from public employers.
Okay, thank you. And then my question, it really goes to, why are we doing this now? And I say that because last week we sat in a hearing, the York County delegation, we hosted a hearing on the Trump tax cuts. And we heard from employers about, what the economy is doing right now and how employees are receiving, more in their paycheck. They're receiving better benefits because of these Trump tax cuts. And the Department of Labor, at the very same time at the federal level, is also undergoing their own rulemaking. So one of my concerns is, we're seeing all of this at the federal level. The economy is doing very well right now, and the Department of Labor is taking a look at this. The task force was completed. That study was completed last year before the impact of, the Trump tax cuts and a lot of these positions that we're talking about could be impacted positively by these tax cuts. And what I see happening is if Pennsylvania steps out there and really goes forward with this rulemaking, we're going to have a situation where you have the federal government proposing rules, the Department of Labor here in Pennsylvania imposing rules, and then our employers are going to have to, figure out the mix between federal and state regulation. And that burden right now, I'm sure is going to be, we're going to hear from the employer panel later, is going to be very, very, very costly to comply with. So, why do we need to do this right now? Why aren't we saying pause? Let's see what happens at the federal level, and then really try to make sure we get this right for our employers and employees across the state.
Thank you for the question. We feel that the administration feels that 40 years is pause enough. There have always been differences between the federal law and the state law, and this would be just a continuation of any differences that may occur. And we know that the federal process has been delayed for quite some time. It is beginning again, but we have no idea of when and if that will be resolved. As far as the tax cuts go, I think if you look historically, wages have remained, even before the tax cut, wages have not grown significantly over the past, if at all, over the past few decades. They've been stagnant. They remain stagnant at about 2.7% a year growth. There are a lot of independent looks at the recent tax cut. I have some information here from the Center for Budget and Policy Priorities. 70% of the benefits of the legislation will benefit the top fifth of wage earners, including over $17 billion in tax savings and nearly $700 billion in stock buybacks. Brookings Institute had similar findings that it will benefit high-income households. The economy as a whole, big picture, is doing better. But when you go a few levels down and you look at unemployment rates, for example, among minorities, people with disabilities, women, those returning from incarceration, those rates are much higher. ESL, immigrants, those rates are much higher, and they are not part of that recovery. And we believe that this change that has been 40 years is long overdue to help bring those people into the recovery. And that's why they're being proposed now.
Also, I'd like to follow up on what the Secretary said. I think it's also important to remember that the federal law does not cover all employers and employees. The Pennsylvania Minimum Wage Act is kind of like a catch-all for all employers and employees. And I think it's only fair that all Pennsylvanians be protected equally.
Thank you. Representative Kruger-Branicki.
Thank you, Mr. Chairman. Thank you, Mr. Secretary and Deputy Secretary, for joining us here today. I want to say, first of all, thank you for hearing from stakeholders and agreeing to extend the public comment period. I think the fact that we've heard from almost 1,000 people on this proposed regulatory change is very important. And I know that you said previously that over 60% of the comments were positive or in favor of the regulatory changes that have been proposed by the administration. Can you give us some themes or sort of top lines on what the public comment said? I don't know that many folks here have had a chance to read all 1,000 comments.
Well, I can tell you just some of the highlights that we've reviewed, and I'll ask Secretary Berrier to jump in as well. But some folks who were told that they would get a raise when the federal rules changed, when the federal rules didn't change, no raise. Some of what Representative Nielsen referenced before were people that are labeled as a vice president or a manager, where their duties are the same as the hourly employees, but getting that label exempts them. I guess for me, they're the two major themes that jumped out, and the misclassification that we were discovering, most of it unintentional, I believe, as people said, well, we thought nobody who was salaried was allowed to get overtime. So I'll turn it over to you, Jen.
No, I think that pretty much covers it. I think a lot of the comments we received kind of reinforce the theme that the misconception that if you're paid a salary, you're not entitled to overtime. And if you're paid a salary, you're automatically exempt from overtime and minimum wage, which is definitely not the case under the Act or the regulations.
And I appreciate you taking initiative to start to explore this issue. I was born in 1977, and I can tell you that the cost of living and wages and inflation and everything else has changed significantly in the past 41 years. My last question, I know that the next panel will include a lot of testimony from nonprofit service providers. What do you think the impact will be on nonprofit service providers, especially folks who care for seniors or children or folks with disabilities?
So this is actually a topic that's very near and dear to my heart. I have a brother who is severely autistic, unable to perform basic life functions, and he is the recipient of many of these services. So I was very interested in the public comments we received from the agencies that provide these types of services. And we reached out to DHS to kind of get an explanation of how this would work. And it was our understanding that many of these employees are hourly employees, and if they're not, they probably should be our hourly employees because they don't meet the duties tests of the exemption. However, we are willing to work with nonprofits to and with the legislature also to try to get the funding that would be necessary to make up any kind of difference or loss that they would experience due to this threshold increase.
And we have talked to DHS as well.
Right.
Okay, thank you so much.
Thank you. Representative Nelson.
Thank you, Mr. Chairman, and thank you for your testimony today. I recognize the importance of, hey, we're taking a look at a 40-year window, and I share some of the other representatives' concern that we might jump out ahead of a federal rulemaking that may create additional gaps between the two. The first part of my question would be if you could touch on how the department determined these new increases, that because it looks like, first it would maybe be about 30,000, assuming, 50 weeks a year work, then it goes to 38, then it goes to like 46,000, which is really impacting a large portion of the workforce. And if that is an adjustment of an equal cost of living, the second side of it is touching on that unintended consequence. In the report, when they talk about 0.1% of payroll, if on one hand we're going to be reestablishing a middle class because of all the extra work or pay that workers are going to be getting, it seems like the financial impact would be greater. That if employers are going to be paying more to be recreating this middle class, that the impact would be greater than that 1%. My concern is under that unintended consequences. From my perspective, one of the downsides of the national health care was that 32-hour mark. And so what it caused to a lot of workers was they lost time that they were allowed to work, and now they had to work 2 jobs in order to achieve that same wage. So if an employer in an area where we are hurting to find workers now has an employee that can't go above a new government-established threshold, this might also have a worse effect on the employees themselves. Part of that unintended. So I know it's a 2-part question. It just seems like this is much bigger dollar amount, and the steps from the salary increase, is that parallel to cost of living over this time period?
I'll get it started, then I'll refer to Secretary Berrier. When the 1977 regulations covered 60% of salaried employees, currently we cover 7% with the numbers that are there. The numbers that have been recommended, when they get to the end of that 3 years, the plan is to find that 30th percentile. So we'll cover about 30% of workers. So it still does not do what the original regulations, the current regulations did. We understand what you're saying about the unintended consequences. But before I do that, can you talk more about how we got those figures?
Sure. We relied on the Bureau of Labor Statistics on the census statistics for the Northeast region. And I think that what we tried to do was try to kind of make it fit with what the federal proposal did as well. They used the 40th percentile of the South region. So that's kind of how we came up with our threshold. And we wanted to keep pace with the economy as well, which is why we have it adjusted or tied in with the adjustment with the census.
One thing I'm allowed to answer, I think, another part of your question, and let me know if this is doing that. That 32-hour piece you talked about, there was no requirement for businesses to do that. That was a decision that businesses made. So they could have raised salaries. They could have kept the hours where they were. They could have hired more people. There's a lot of different options that were available other than cutting people's hours, and that would be the same under this act.
Well, I think that kind of underscores my concern for jumping ahead of the federal, because what actually happened was it hurt workers because they had to have 2 jobs in order to achieve that same minimum earnings. And my concern is that an employer may say, or, hey, we got to make sure you don't go over this threshold because we just can't afford to continue to do this. And so it may hurt workers. I understand the direction that you're going, and a great example of explaining the number of population you're trying to capture. It's just from an employer mindset, I'm thinking, wow, this could really create an additional ceiling that the workers, if you're a factory worker, hey, boom, you're done at this point, and somebody else is going to be coming in here.
With that example, sir, factory workers would not fall under this exemption since that is production work, and these exemptions cover white-collared work. So I think we have to make sure that we're addressing the appropriate population when we're discussing this topic.
Thank you very much. Moving on to Representative Mullery, and I'm going to remind folks we are officially behind schedule, and so those of you who are asking questions, I'm here all day, so you can continue to ask questions, but we are behind schedule.
Thank you, Mr. Chairman. Briefly, I have some questions about the investigation and enforcement. You indicated that it is assigned to a district office and then an investigator within the district office. How many district offices are there? How many investigators are there?
So currently we have 5 district offices, and unfortunately, due to budget cuts, we have 27 investigators at this point. But we'd happily take more money to hire more investigators and provide more enforcement for the act.
Unfortunately, I figured that your answers were going to be along those lines. If you only have 27 investigators, what type of caseload are each of those looking at?
Oh, they have voluminous caseloads because they also cover 12 other laws in addition to the Minimum Wage Act.
If you could, for us, can you give us an analysis? How has that staff changed, let's say, over the last 10 years? I mean, have you lost people and not replaced them?
We've lost people naturally through attrition, and it's been difficult with this economy and trying to find qualified people for the salary that we're offering.
Briefly on the investigation part, you indicated that when an investigator receives a complaint, goes into the employer's facility and conducts his review, he reviews the records of all employees.
Correct.
When that occurs, are you able to give us any statistics, raw data, as to how often they find violations with non-complainers, for lack of a better, non-complainants?
Right. I don't actually have specific statistics with regards to that, but I could try to get you those statistics. What I can tell you is that since 2015, we have had 1,500 complaints, and the Bureau has collected $6 million in wages for workers in Pennsylvania.
And finally, if I understood you correctly, there is no penalty. It is strictly a reimbursement of past due and owing, and then what? A mandate that the payroll going forward meets the criteria?
I don't know if we have the authority to mandate that, payroll meets the criteria, but I think what's most important is to educate the employer to make sure that they understand the rules and the regulations by which they need to apply under the Minimum Wage Act, which is what we try to do.
Last question. I work for a company. I feel that I'm being not paid adequately. I make a phone call. The investigator comes in and says, "You're absolutely right." I get my money, I get my reimbursement, and I'm an at-will employee. And 2 weeks later, I'm terminated, and I am replaced by somebody who they are paying what I was getting paid before I called and made the complaint. In that instance, is there any penalty or punishment for the employer? And that's my last question. Thank you, Mr. Chairman.
I'd have to look into that. I don't believe the Minimum Wage Act has any whistleblower protection, but I would have to look into that. And also, I forgot to mention earlier that I do want to get out there. If an employer disagrees with the Bureau's determination of finding an underpayment under the Act, the employer can appeal the department's determination.
Representative Lozier.
Thank you. Can you hear me? We're pretty close. So. Just to clarify, you were talking about the percentages that you just mentioned. What's the average pay in Pennsylvania right now? Average salary?
I don't know the median right off the top of my head, but I could get that for you.
Okay. And the reason I ask is the ability to say, can you explain a little bit more? You were talking about the 6%, and you're trying to go up to 30%. But my understanding for the average salary is less than what you're proposing. So I'm just trying to figure out the percentages that and I'm assuming it's going to go down to the fact of who's included in this worker group that you're talking about. But I guess, do you understand what I'm saying in the sense that you're saying we're only at 6%, but these salaries that you're trying to increase it to me, look like it's going to go over the average salary that for Pennsylvania as a whole. So how are we only going to be at 30% or that?
Based on the BLS, the Bureau of Labor Statistics data, that 47,000 annual salary is the 30th percentile. So based on those statistics, I would have to assume that the median would be higher than the 47,000.
Okay. Well, I'd be interested in that number because my understanding was it was lower than that, but that's fine. And the second question that I have you've determined that the increases, the 3 stages of the increases, one of the biggest issues that is hanging out there is the fact that, especially with the last one, in the 2 years after the effective date of 9/21, the federal court case that has stayed that level when they tried to do it at the federal level. So why would we try to do something that's already been stayed in the federal courts?
Sure. Yes. So the Texas District Court struck down the federal proposal, but that's also a federal court interpreting federal law, and I think it's important for us to move forward with Pennsylvania law and, protect Pennsylvania citizens.
But wouldn't that be in direct I mean, there'd be precedent set as to the fact that this was not...
No, that's actually the federal, there would be for another federal attempt, but for the states are not preempted from moving forward under their own individual law.
Okay, so even though the federal court said this is unlawful, the state can go ahead and do it anyway.
Well, it's a different law, right?
I just think that would be kind of an uphill battle just when you come to the arguments that were already made for the level, because they were talking about the fact that the tests would be meaningless if it was at that level of pay.
At that region in Texas, I mean, because and I'm not by any means a very well versed in the federal arena, but federal courts. No, that's fine. Federal courts tend to hear what's in their region. So the federal district court heard appeals from, whoever appealed in the Texas region. So that's a regional court. Regardless, it doesn't matter because this is state law, and state courts interpret state law, whereas federal law is interpreted by the federal courts.
Learning from other states has been kind of how we've gone along. So that was one of my... Okay, and I'd be interested in knowing that average and understanding that percentages because I just in my math in my head. So,
and since you mentioned other states, I just wanted to mention that also New York is planning to have a salary threshold higher than the one that we're proposing by 2020.
Okay, and how far along are they? Do you know?
I'm not quite sure, but they're already in the process.
Okay, thank you.
Representative Miller.
Thank you, Mr. Chairman. I'm sorry, and just so I can be a little clear too, when you said 30th percentile, just so I can get it. If the broadest reach of your proposal were to be enacted, what percentage of Pennsylvanians would be protected by it?
We know the number is about 460,000 people.
Okay.
So that's right now there are over 6 million people working in Pennsylvania. So I'd have to do the math, but it's a relatively small percentage.
Okay. So if I get it straight, then about 460,000 Pennsylvanians currently are working in thresholds, some as low as around $24,000 a year, as salary employees with seemingly very little limitations as to how many hours they would work beyond 40 hours. Am I correct? All right, so we're saying that there's somebody's making $24,000 a year, a poverty wage if you have 2 kids, right? Somebody's making $24,000 a year in Pennsylvania, maybe doing 12 hours above the 40-hour threshold, and that's allowable now.
If they meet the criteria of the meeting the minimum salary threshold and also the duties test, then that is permissible.
Okay. So I guess what gets me a little bit, and I think I would agree a little bit there with the Secretary's comments listen, my belief is for basically my lifetime, I'm a little bit older than Leanne, but my lifetime here, the standard of living for the middle class has barely, depending on any calculation, barely moved in my lifetime. And when you go into the numbers of the middle class, or what used to be the middle class with it, it's actually worse performing. So I'm ecstatic to see some of the numbers that some people's 401ks and everything else are working for it. In the meantime, for 40 plus years of my life, this is happening in Pennsylvania, where somebody's working $24,000 a year and being told, well, hey, sorry, we're going to cut you out because we classify you differently. You have no protection. Good luck with it. But $24,000, don't worry, because the federal government or the state government will then pick up what we're not paying you. So we're going to dump the fact that that's not a family-sustaining job, a full-time family-sustaining job. It's not that. You're working more than 40 hours a week. And by the way, we're going to be sure that the public will pick up the cost because you can't afford to live without some assistance, because you might need help with childcare or something else that the government will pick up because the industry won't pay for it. It amazes me the amount of these classified jobs that end up being things that the public ends up paying for because we seemingly accept from industry, well, hey, it's okay for you to pay somebody $24,000 a year and we'll pick up the remaining of the tab to support the family. If they're working 40 hours a week, if they're working for $24,000 a year, anything above 40 hours a week that they're not getting paid for is abuse. It's abuse of that individual. That's it. And the answer can't be, well, hey, listen, here's our problem. We have sectors of our economy that are basically abuse funded. That, hey, we've structured it, so yes, please, public sector, pay for these people's health care because we just can't do it. We're dumping it on you. The answer can't be we'll create more sectors of abuse or allow them to foster. The middle class isn't growing, and the lower middle class is being screwed. I appreciate the ranges, and Representative Nelson was much more articulate than I am regarding some of the higher threshold jobs that you're qualifying. But there should be no job in the state of Pennsylvania where you're making less than $35,000 a year, and people are saying to you, hey, you have no choice how many hours that you have to work, and we're not going to pay you for it. To me, it's an abuse. I appreciate your effort in trying to rectify it, and I strongly believe that this is something that should be done. Thank you for your testimony and your time, Mr. Chairman.
If I could, Representative Miller, that is exactly the kind of thing we heard as part of that middle class task force from the people who spoke to us. Not often with the same passion and intensity, but their concerns were exactly what you're describing.
Thank you very much. This panel has taken up a full 1/2 of today's hearing on this issue. So anyone concerned about fairness, I think your concerns should be allayed. And we're going to move on. And the next panel,
thank you.
I would like to ask our employer panel to come forward. Joining us now to provide insight into how this proposal will affect employers and many of their employees, we have Kathy Speaker McNett. We have Elizabeth Hayes, Director of Human Resources at MHY Family Services, Meredith Bolamer, General Counsel and Vice President for Legal Affairs, Mercyhurst University, Sky Fogel, President, Skirmish Paintball, Leah Yaw, Senior Vice President and Chief Strategy Officer of Devereaux Advanced Behavioral Health, and Robert McCaffrey, North Country Brewing Company. And I'd like to remind all of our panelists today to please summarize their testimony in 5-minute statement, and we'd like to leave a little bit of time for questions and answers. Our research analyst Shannon Walker at the end of the table will give you a 30-second signal. Of course, you don't need to take all 5 minutes because I'm sure this panel can take up your time in asking questions. So we will begin with Kathy Speaker McNett and then just hopefully go down the line as orderly as possible. Thank you. You may proceed.
Thank you, Mr. Chairman and members of the committee. I want to start with the fact that it's a distinct pleasure for me to be here this morning because I used to sit in John's seat many, many years ago and enjoyed great relationships at that time with both labor and business. So I very much appreciate being back. I have the distinct pleasure today of speaking my own voice, which doesn't happen very often for an attorney. I am not lobbying on this issue, although I do lobby. I am not lobbying this issue before the legislature on behalf of any client. The comments are my comments as a result of working with the House committee, going into a legal career in labor and employment law, sitting on the ABA committee, and authoring a number of articles and a section of a Pennsylvania book on the minimum wage. So enough about me. Historically, I want the committee members to know that you are talking about a law that started out as what I call a little Fair Labor Standards Act, a little FLSA. That is, the only jurisdiction of this law was over the smaller businesses that weren't covered by the federal law. So dividing line, federal law on this side, Pennsylvania law on this side. So Pennsylvania law could do anything it wanted to cover the smaller businesses. You could have accommodated your concerns about a library. You could have accommodated if the library was small enough to only be under Pennsylvania law. You could have done that sort of thing. In 1988, after I left the committee, the legislature made the decision to include all employers under this law. And you have set up what I want to call the non-compliance trap. I'm going to deviate from the dollars, and I know that's a hard sell for some members on the committee. But I'm going to deviate a moment from the dollars and go into the non-compliance trap. I have no sympathy as an attorney, as a person, for people who know what the minimum wage is, what the rules of the game are, and violate those laws. If you're not paying people $7.25 an hour for hourly people, you got a problem. And that's going to be a problem that can either be reported to the Pennsylvania Department of Labor, the Federal Department of Labor, or can wind up in what's called a collective action or a class action in a lawsuit or an individual lawsuit. So there are lots of ways to go at enforcement. What I call the non-compliance trap, and I've defined it at page 3 of my testimony, is the time when the employer is really trying to comply and just doesn't know enough about the nuances of this law to know the difference. I must say that I agree with Deputy Secretary Berrier when she says that there's probably a lot of misclassification out there. A lot of people don't understand that you cannot just pay salary and not pay overtime. These are more nuances of the law that lots of people still don't get. In fact, in spite of the fact that the federal law has been in existence since the 1930s. So now we've got this non-compliance trap set up. If we adopt these levels, threshold levels, as a state, and continue adopting them every 3 years under the escalator clause, as the regs specify, and I'm not talking again about the dollars. I think that's a legislative determination, a regulatory determination that needs to be made. What are the proper dollars? But if it's different than the federal, we run the risk that employers trying to comply with federal law, which is better publicized, don't comply with state law and wind up in this non-compliance trap. So the initial levels, the 610, the 766, came right out of the federal regs that were stayed. The 921, I believe, is $8 higher than the threshold, which was actually adopted in 2016 by the feds before it was stayed. So you have this weird idea of the different thresholds and different years of implementations. So now you've got listening sessions going on in big cities around the country, and I don't know what comes out of that. I suspect it will be lower than the thresholds might have been had they continued on, but going somewhat toward Representative Delozier's comment, you know, how these sort out, I'm not sure because I haven't seen the escalators. Nobody's seen the escalators that are going to be applied. So that's going on. At the same time, I believe you have some different percentiles. I think the state has been talking about the 30th. At some point, the feds were talking about the 40th percentile. So they may still go up. And then if you're complying with the Pennsylvania law in good faith, you may be what I call dirty under the federal law, clean under the state law, but dirty under the federal law because of the non-compliance trap. Example that's in my testimony, and please, 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 I will be happy to talk to anyone specifically about the fluctuating work week, but I would prefer not to describe it in great detail here because I will bore you all beyond tears. It's a weird thing that's allowed by federal law to pay people on a salary, okay? Federal law for years has said you can use fluctuating work week. And under fluctuating work week for feds, the salary covers all the time worked, and you pay an extra 0.5% for the overtime hours. Feds have been doing it for years. General Nutrition had a case that went to the Superior Court in December. Superior Court here said, can't do it, have to pay 1.5 times. So under federal law, you could be paying somebody making $10 an hour, $5 for all the extra hours. If the case is sustained as it is with the Superior Court right now, Pennsylvania employers and anyone doing business in Pennsylvania would have to pay $15 an hour for the overtime hours. Again, if the rule is clear, you should obey it. But I dislike this non-compliance where you go with a rule and find out it isn't good. So what can you do about it? One page, my testimony at footnote 18 talks about Senator Baker's bill, where she says, do we really want to go along with the feds or don't we? Let's be clear about that. And I would ask that you look at that. The feds also allow for a paid program where you can voluntarily have an employer go into compliance if they have misclassified someone, for example. We have no similar program. In my estimation, I would wait for the feds to act because it sounds like they are planning to act, so we don't exacerbate this trap. I would not adopt all the bracketed portions of the regulation. There are some very unintended consequences in those brackets, I believe, including what's called the sole charge exception. So be very careful of those brackets. And also, brackets mean you've changed something, and that can be a difference for court interpretation. And then I think you've got to solve the underlying problem. Are we going to follow what the feds are doing or not? If we are, I think we need to say so. If we're not, I think we have to say that clearly. We did in the health industry when you passed the Overtime Act for the health industry several years ago. So again, my thanks to you for being here. I appreciate being here, and I hope you will at least take my remarks verbally and in writing into consideration. Mr. Chairman, if I may, if any of the members have questions that they'd like to reach out, or staff, to me after this so as not to take the committee's time, please feel free to do so.
Thank you very much. Moving on, Elizabeth. Okay. I didn't know where we were on the, okay.
Members of the Labor and Industry Committee, thank you. Thank you for the opportunity to join you today to discuss the impact the proposed changes to the Pennsylvania overtime regulations will have on my nonprofit organization. I'm Elizabeth Hayes. I'm the Director of Human Resources for MHY Family Services in Mars, Pennsylvania. I appear before you today on behalf of my organization and the Pennsylvania State Council of the Society for Human Resource Management, or PA-SHRM. The PA-SHRM State Council has more than 12,000 members in the Commonwealth of Pennsylvania. MHY Family Services is a nonprofit organization serving youth and families by providing support and services that afford opportunities for better lives. MHY offers comprehensive residential, educational, and community-based services responding to an array of hardships and traumas, including mental illness, behavioral issues, abuse, and neglect. For MHY, literally, this overtime proposal we're discussing today to more than double the salary threshold presents the risk of my organization closing its doors. As a nonprofit with a very limited ability to affect rate setting for our services, we already often find ourselves unable to provide pay increases and hire additional employees. In the worst case scenario, I estimate that these changes could result in more than $750,000 of unfunded costs. This would be nearly a 9% unfunded increase to our budget. Let me highlight some specific challenges my organization will face if these proposed overtime regulations are implemented. To be clear, most of MHY's exempt employees, senior and middle managers and professionals, are currently paid less than $50,000, and under the PA Department's proposal would become eligible for overtime. As an underfunded nonprofit with limited flexibility in the budget, I have serious concerns about how MHY will cover potential overtime expenses while still providing high-quality services for the at-risk youth and the families that we serve. Our nonprofit's ability to provide critical services will be negatively impacted. At MHY, we prioritize a continuity of care model that ensures our youth and families receive services and care from designated therapists and supervisors. Therapeutic services are driven by the relationships that our employees have with the youth and the families to which they're assigned. Months and sometimes years go into building that trust and bond, and this can't be replicated by swapping in another professional to avoid exceeding 40 hours on the part of a primary professional. Under this overtime proposal, continuity of care would be undermined by limiting the ability of our employees to effectively respond to clients' clinical needs, notably in times of crisis. Changes to the overtime regulations will likely require employers to reclassify a significant number of salaried employees to an hourly status. Hourly employees, of course, are paid only for the hours they work and often are forced to closely track their hours to ensure compliance with overtime requirements, which can lead to less workplace flexibility. At MHY, our residential program managers, for example, are provided with workplace flexibility options. If I had to reclassify this position to a non-exempt status, these individuals would lose their ability to leave early on calmer workdays to attend their children's soccer game or take a Friday off for a long weekend, which they are currently afforded to offset long work hours on other days. Employee morale would not only be negatively impacted by losing meaningful flexibility, employees are likely to view the change to a non-exempt status as a demotion. In their eyes, the exempt classification is seen as a promotion, providing a sense of workplace status in addition to greater workplace flexibility to balance work-life needs. I'm confident that our supervisors will view reclassification as a demotion, requiring more oversight from their own supervisors and resulting in a decline in employee morale. Clearly, the department's overtime proposal would have an adverse impact on my organization, but it would also harm other employers across the state, as outlined in PA SHRM's comment letter on the proposal included in my written statement. In closing, I can't overstate how concerned I am with these proposed changes on MHY Family Services' ability to fulfill its mission to serve youth and families in Pennsylvania. Thank you for allowing me to join you today, and I look forward to your questions.
Good morning. Thank you. My name is Meredith Bolheimer. I currently serve as General Counsel and Vice President for Legal Affairs at Mercyhurst University in Erie, Pennsylvania. Mercyhurst is a Catholic private liberal arts mercy institution with over 3,000 students on 2 campuses in both Erie and Northeast Pennsylvania, and we are rapidly approaching our centennial celebration. We offer master's, bachelor's, and associate level as well as certificate degrees. We are home to 22 Division II sports, 2 Division I sports, and 8 National Junior College Athletic Association teams. Some of our marquee academic programs include intelligence studies and forensic science, both housed in our Tom Ridge College for Intelligence Studies and Applied Sciences. With approximately 400 full-time employees and 200 part-time employees, we are one of the top 25 employers in Erie County, contributing hundreds of millions of dollars to the local and regional economy each year. I sincerely appreciate the opportunity to participate today. I'd like to spend a few minutes just briefly in my introductory comments summarizing the primary concerns facing colleges and universities. They are not unlike what the previous speaker outlined for her organization. The negative effects are not unique necessarily to private institutions like mine, but will also be deeply felt at the 14 state system schools. Colleges are unique businesses. The product we are selling is education. Our ability to provide a quality product affects the entire economy, as businesses in the Commonwealth and beyond depend on our ability to adequately prepare people for the workforce, their chosen profession, and the economy of the future. Beyond the tangible and concrete career preparation, we are also charged through our missions with creating critical thinkers, ethical leaders, problem solvers, and good citizens. We, like our colleagues across the state, state take that charge very seriously. The Pennsylvania State System of Higher Education Schools, or the PASHE schools, as you know, are funded through Commonwealth dollars and tuition paid by enrolled students. Most private institutions, on the other hand, are funded almost exclusively through tuition dollars. In a business that sells goods or services, when the cost of employment rises, those costs are typically passed on to the consumer. This is not different in higher education. If our employment costs increase, the only place to turn is to the consumer. In our case, that's our students and families in the Commonwealth, either through asking for more tuition dollars or in the PASHE system asking for an increase in taxes. If our institutions across the state are not able to get the funding increases they need through increased tuition or tax dollars, our only option is to change the way that we pay our employees. So I think part of the discussion today, there's been sort of a, I think, false dichotomy presented that if you raise the threshold to the $48,000 over 3 years, that employers will respond by paying people the $48,000 threshold. I can tell you that, not unlike the library example, an institution like mine, whose cost to comply with the new regulations is about $1 million, that $1 million is combined is more than the total of our margins over the last 4 years of operation. So we simply, at our private institution, again a small private Catholic institution, do not have the funding and are probably already priced at the top of the market in terms of what students and their families are able to afford for tuition. So large groups of our employees won't see that increase at the new threshold. Rather, we will have to wage smooth them down to hourly employees. And I wanted to talk a little bit about why that's so challenging in higher education, especially with certain groups of employees. I'm going to choose one just as an illustration, which would be assistant coaches. I'll venture to say that our assistant coaches, not unlike the vast majority who work in PASHE school systems and most private institutions outside of perhaps the big Division I schools like Penn State, that those assistant coaches consistently make under the threshold. Without some clear guidance from the state as they're doing these regulations, that really puts us in a very difficult position because they are very difficult to pay on an hourly basis. As anyone who has children or has played sports, it is sort of a unique thing. We do have times, and I wanted to speak to Representative Miller's point about the $24,000 a year for asking people to work consistently more than 40 hours a week at a salaried position. We may have coaches, more closely in the mid-30s or low 30s, and there are times when they do work 80, maybe 90 hours a week. If they've had a playoff season or a really successful doubleheader weekend for baseball that's very far away, they are working for maybe 4 or 5 days straight by the time it's all said and done, except when they're sleeping. But that is at the height of their season. The other part of their season, when the students are not here, they're not recruiting, there's no lifting or anything going on, the coaches are maybe working 5 to 10 hours a week. But as you know, in Pennsylvania, we have no ability to pay people on a fluctuating work week, so we can't take that into account. So our only choice, because we don't have the funds in our budget to raise people to the threshold, our only choice is to wage smooth them down to minimum wage employees. So I just think it's important for people to understand perhaps one of the unintended consequences for all of the higher ed institutions across the state is that we are not going to be able to compete with other colleges in other states because we will be paying our assistant coaches minimum wage. So the Federal Department of Labor issued a fact sheet specific to higher education as it went through its process, which has been extraordinarily helpful to higher education. And the main thing I want to ask today is for, especially directed probably at the Secretary of Labor and the rule-making entity, is to keep in mind that higher education is desperately in need of guidance at the state level for certain categories of employees, and we would ask that they model that guidance on the federal regulations. So I see my time is up. Thank you again for allowing my participation.
Hello, my name is Sky Fogel. I'm both the owner and manager of Skirmish Paintball and Pocono Whitewater Rafting, located in the Pocono Plateau of our great Commonwealth. Like many other businesses, from local ski areas to zip lines and water parks, both businesses I operate are small, highly seasonal, and rely heavily on salaried staff to help us even out our labor costs on our yearly budget. Our employees, similar to us, frequently ask to be placed on salary to help them with their own household budgeting. That being said, all of our employees and myself put in very long hours about 3 months out of the year and take much shorter, relaxed hours during the rest of the year. No one's going rafting when you can go skiing, right? Our salaried employees find comfort in receiving a stable and consistent paycheck throughout the year, as many of them have families to care for and feed. The proposed law would financially force us to return many of our salaried employees to an hourly rate, cutting their hours during the busy season and hiring more inexperienced staff to fill in the gaps. Furthermore, we would be forced to lay off the new hires and drastically cut the hours of our original salaried employees for the shoulder seasons, forcing both groups into unwanted second jobs. As I mentioned before, many of our salaried employees have families, children, grandchildren, husbands, and wives. The flexible, self-managed schedule they rely on is a godsend for one of the kids comes down with a flu, has a once-in-a-lifetime dance recital, or makes it to a basketball national finals, all of which have happened this year alone. Skirmish and Pocono Whitewater are simply too small to hire an HR specialist or compliance officer to try to understand the new regulations, and creating a management/maintenance system for them would be a monumental endeavor for myself and our company's bookkeeper. This will greatly reduce the amount of time I have to search out new business avenues and ensure our company's continued growth. Small business owners like myself work tirelessly to follow the rules, but state and federal regulations are different. So it's like playing a football game with 2 separate rule books and 2 separate referees. Small businesses simply don't have the resources to have a lawyer on staff or even an HR person to help make sense of this quagmire. A multitude of studies have shown that a stable regulatory environment is best for business growth. With climate change wreaking havoc on the outdoor tourism and entertainment industry, the last thing we need is for government regulations to be changing as dramatically as the weather patterns. All of our employees, salaried and hourly, are counting on our elected officials to keep our regulatory environment stable. I also have some issues with how this rule doesn't take into account the vast differences in cost of living from region to region in Pennsylvania. Everything is cheaper in Carbon County, especially compared to Philadelphia, yet the rule blankets both regions in the same way. I live in Jim Thorpe in a 3-bedroom home only 2 doors down from mine, just sold for $40,000. I didn't get into this business to shuffle papers and try to understand and apply rules and regulations. I got into it because I love sharing the experiences and beauty of the great outdoors with my guests, many of whom have become close friends. As a 3rd-generation family business owner, I'm begging you to cut the red tape, not make more of it. This is why I asked the committee and the department to withdraw their proposal and help keep at least one of our small business legs on as firm a ground as it can be. Thank you all for your time, your hard work, and for giving me a chance to speak.
Chairman Kaufman, Galloway, members of the committee, my name is Leah Yaw. I serve as Senior Vice President and Chief Strategy Officer for Devereux Advanced Behavioral Health. Thank you for the opportunity to be here and to attempt to represent the nonprofit dynamic. I was delighted to see how much conversation there was on that issue in the first part of these proceedings. Very quickly about Devereux, with programs in 13 states and an annual budget that exceeds $500 million, Devereux employs more than 7,500 people around the country, about 2,400 here in Pennsylvania. This year we'll care for about 25,000 individuals around the country with intellectual and developmental disabilities. We have a very strong specialty in autism, and we care for children, adolescents, and teens in very serious mental health crisis and child welfare situations. Devereux is doing some really groundbreaking work. We're working with some folks who've been through the unimaginable, girls who've been commercially sexually trafficked, foster children who've been in maybe 15 or more foster homes over the course of 10 years of life, young adults with autism really fighting for inclusion and a place in the community. It's important work. We do it around the country, but for sure our hearts and our roots are here in Pennsylvania. For the nonprofit human services field, Governor Wolf's proposal is a complex one to evaluate. We are acutely attuned to the fact that the caliber of the staff we employ is directly related to the quality of the services we can provide. There's really no more direct line equivalent in the work that we do. The importance of employing qualified, compassionate, well-trained staff it cannot be overstated, and we understand that offering good, fair, meaningful compensation and a healthy work-life balance is really a key piece of that equation. When you couple the importance of that with this really well-documented healthcare staffing crisis that we are dealing with in Pennsylvania and around the country, this issue just couldn't take on more significance for the nonprofit healthcare environment. Devereux believes that it is the responsibility of all employers to really strengthen our middle class. We see that as part of our obligation to the community. We also see it as really one of the most important things we can do to improve the quality of our services and to help more people. In fact, regardless of the outcome of these proposed regulations, Devereux is fully committed to increasing not just the compensation of salaried employees, although absolutely, but also the compensation of hourly employees that fall below these thresholds we're discussing today. In fact, for another conversation another day, Devereux would submit that the most important thing perhaps that we could do to improve the outcomes of healthcare, and particularly nonprofit healthcare in the state, would be to improve the compensation and the expertise of hourly direct care staff. They do the yeoman's work really in this field. So I provide these details just to express our sincere support for the fundamentals that underpin these conversations and what the governor and all of you are trying to achieve. The question, we believe, is not whether we need to increase compensation. It's how to do that without compromising an employer's ability to maintain its status as a meaningful employer and a provider of service. The evaluation of this issue looks different for us in the nonprofit realm than in the for-profit. And I don't mean to suggest this is a simple calculation for anyone, not for for-profits, not for nonprofits, but where for-profits do have some ability, or a decision at least, to pass some of these increased costs onto their end users. Nonprofits, and particularly in the healthcare reimbursement environment in partnership with the state, just don't have that ability. That's not even something we can entertain as we think about how to manage these issues. I know you're all acutely aware of the operating challenges in the nonprofit environment. I know you discuss that a lot in this committee, and I won't belabor today's discussion with too many details, but I think it's important to note that the nonprofit healthcare providers in Pennsylvania, and particularly those of child welfare services and medical assistance funded behavioral health care, do not and have not experienced any kind of predictable service rate increase pattern that fairly aligns with the reasonable and routine costs of recruiting and retaining quality staff. This is a conversation that we have with you every year. I know you understand it, but it's very complex, and when you layer on requirements, it becomes more complex. So Devereux is in a unique position. We're a large organization, we're well funded, and we've had the ability to build an endowment and meaningful fundraising support. That is unique in many ways in the state, in the healthcare nonprofit environment. We're in the enviable position of being able to look at this. We've been looking at this before the conversation started at the federal level. We're really focused on a triple aim plus goal. We want to improve employee satisfaction while at the same time improving the quality of care and the outcomes in the healthcare environment. We are in a position that most healthcare nonprofits are not. They're really struggling to simply operate successfully in an environment where reimbursement for services doesn't meet the actual cost of treatment. And so I see that my time has expired here. What we would ask is for you to consider the impact of unfunded mandates on the nonprofit healthcare environment. In a general way, Devereux is fully in support of the goals here, and we want to do this, and we're going to do it regardless of the decisions you make in this committee. But this unfunded mandate environment that the nonprofit environment exists in is really very complex. And I think that all of the unfunded mandates in the last decade are good and important pieces of doing better work on behalf of those we serve, but unfunded is unfunded. And so we would ask that you have discussions about how to work with the department, perhaps on supporting rate adjustment processes that would help support nonprofits that are really not in the position of Devereux to continue to do the work they do while meeting any of the regulations that you propose today. Thank you very much for your time.
Thank you, everybody, for inviting us to speak today at the panel here, and appreciate your time and considerations on all this. I'm Bob McCafferty. I own North Country Brewing Company. I just want to give a little background onto my business, and Because this is a very personal issue with me. Actually, I try to keep it about math and numbers because they don't lie and they don't have emotions. But we just had a chance to do something and followed a dream, and it worked out. It doesn't always work out, obviously, but we couldn't have done that without our employees. And I have 10 fingers and half a brain some days. So other than that, we definitely appreciate our employees. I had 4 part-time jobs after high school, and I got sick of a beer-soaked carpet, and roommates. So I knew I needed better skills, really. And so I just I got in the restaurant industry, started a dishwasher, made it through the stations, progressed up in pay doing that. It ended up paying for 2/3 of my college and my cars that ran, my apartment, and my books. That's what I believe that, the freedom to do and, improve yourself can do. I was in the field for years and ended up in something that wasn't even my degree, but I had to learn more. And I progressed from a field tech to crew chief to field director. And at the time I left in 2001, I was at $35,000 a year. I put 60 hours a week into my company and usually had to travel both ways to the job site. So I'd up to 18 hours of drive time a week that was on top of the 60. My decision at the time was to get back to school and get a doctorate or, do something completely different. And obviously I did something completely different and renovated a building and opened a restaurant. And, one thing with my employees from day one, you can ask all of them, and honestly, I'm willing to sit on any committee or answer any questions anytime, and my employees would as well. I only ask them for 40 hours. Some of them meet 40, some make 45, some do 50. I actually say in our handbook, don't do 45 plus. I don't want that. I'm not going to be the employer that I came from, that I strove to be better than. And, so I'm just, taking this to heart because I always thought our salary level is based on reward. You're hourly and then you get a reward. You're on a salary, you're on a pathway to career. And we try to choose people in our industry. We try to choose people that get it, want it, and can do it. And they have to smile from within because you really can't train that. And it's a hospitality industry, so that's what we do. I have an executive chef that started with us as a dishwasher 10 years ago. He's a great guy, has a family now, graduated Slippery Rock University, but continued on in our company to this day. There's a lot of examples that way. We've trained a lot of brewers that didn't know how to brew beer, and now they're brewing at other places. I didn't have a position. They grew and learned, and I didn't have anything to offer them in my company anymore because that position was already filled. So they moved to other breweries, and now they're brewing excellent beer in our state. And that's the industry that we are. The unfortunate part of our industry is it does exist on 6 pennies. And I almost closed a year and a half into it because out of all my previous experience, I didn't realize that restaurants exist on 6 pennies. That's 6%. Every dollar that comes in, 6 pennies is what we pay for a new cooler with. We abuse our equipment. We heavily use our facilities and have to keep them clean and maintained, and because we want to. But I'm just saying that's a cost. Lately, the past I'd say 8 years, our municipality now is having a new regulation. It's a fee. You have to get your backflow preventers inspected every year. Again, all these regulations and mandates are necessary, obviously, or they wouldn't be here. But I'm just saying it's another cost. So that in our world, if a burger is gifted away or dropped, our plate cost on that burger is $5. We sell it up to $15 on the menu. We actually literally have to sell 83 more burgers to pick up that one burger that we wasted. And that's the restaurant industry is different that way. We also have retail. We sell hoodies. So retail businesses, as far as I'm aware, and what we do and what I'm pretty sure retail does, they exist on 50% of their profit margin is 50%. So if we have a hoodie theft or damaged, we actually have to sell 4 of those because it's a different margin. It's a different profit margin. So the only thing in closing that makes me nervous about this particular bill is that it's a broad paintbrush across all business and across all employers. And I always believe that if you're a bad employer, you're not going to be in business long. So, I I think that there might be bad employers out there, but, thank you for your time.
Thank you very much. And we're going to move on to questions for the panel, and we're going to start where we left off, and that would start with Representative Topper.
Thank you, Mr. Chairman. I think we're all in agreement that we could use a committee tour at Mr. Fogel's establishment, following that with a committee tour at Mr. McCafferty's establishment. So I guess that's right. I think it'd be great.
You do those just in case.
I'm concerned about the threshold that will be adjusted. This threshold will be adjusted every third year after the rule takes effect. I mean, one of the things that we're able to do here from a public policy perspective, I mean, this is not a bill that we're getting ready to vote for. This isn't something that will be implemented in what I would consider a non-legislative way. One of the things that we can do when it comes to bureaucracy, we at least have the opportunity as the people's voice to ask questions like we're doing today, to actually bring stakeholders and just start to talk about what effect it might have on our economy. My concern is that just simply adopting a rule and then having it take effect, ad infinitum, just continue to increase, will not allow us that opportunity. Is that a concern that any of you have when you look at the rule and you see that this could go on, every third year, just continue to be increased and more of an increased cost without knowing what the economy is going to be any of those years, unless, we all seem to have kind of a unicorn thought of what the economy is going to be like, but we don't have to go back into too far of history to see how those things can change. So if somebody could just talk about that part of the rule, please.
I'll be happy to take the first stab at it. At least a number of years ago, some of you, I believe, were there at the time when the legislature decided that increases in unemployment compensation for the maximum benefit amount would not go up. You capped it because of concerns about the growth in the economy and other things. That is the sort of thing that I think you're talking about. My other concern is that whether or not it is appropriate on an economic basis for this regulation to continue to escalate, the numbers will probably continue to be different than the federal numbers. So my non-compliance trap will continue potentially ad infinitum, because I doubt very much that we're going to guess at the same exact number that the feds are if they ever get a regulation through that is no longer stayed. So yes, I've got that concern.
Yeah, and from a practical standpoint, just in terms of getting back to the institutional perspective for private institutions across the state and also state institutions, although funded by tax dollars, is higher education. There are existential threats across the country. For those of you who have universities in your districts, small private schools in your districts, I'm confident you understand the struggles that they are dealing with. We see institutions closing and struggling to stay alive across the state with lots of existential threats coming from community college and the debt crisis and all of these things. Again, these institutions typically are not flush with cash, and I can speak from my own institution's perspective. So when we see a rule like this with every year we're going to have to continue adding this cost to our budget, we have to also, on the flip side of that ledger, figure out what we're cutting. And at some point, the only things left to cut are, again, student services and how much we're able to do for our students. So we're asking them to pay more, increase what they're paying to go to college, and we're giving them less because we have to continue to budget for these continued increases in the salaries that we frankly, we can't afford and we don't have the funding for.
Well, and if I could take that from a human service standpoint just a little further, I heard references today from the Secretary of average increases of 2.7% per year, if I'm not mistaken. There are years we haven't given increases to our staff where we have unfunded mandates that we're adapting and responding to. There are organizations, human services organizations in Pennsylvania that haven't had increase in their rates for over 20 years. We haven't had increases in most of our rates in over 10. Probably quite a bit longer than that. So while there's obviously increases in the cost of living, and now we're looking at a legislation that's going to impose corrections on a regular basis, there's no way human services industries can sustain that. We're already starting out of the gate in the hole on this matter.
Thank you, Mr. Chairman.
Thank you. Moving on, Representative Donna Tucci.
Thank you, Mr. Chairman. And thank you, everybody, for being here. I don't think this works. So I understand the concern for flexibility, but I do have a question about compensatory time. Is it currently legal for any businesses to provide comp time?
I'll take that for starters, and then certainly comp time in lieu of required overtime payment is illegal in the private sector. And as you can tell, I've taken a lot of specifics on that because everybody thinks comp time is fine and it can be in any work week. No, that is not correct, but there are some public sector abilities to maneuver. The thing that is legal is for an employer to say, you've worked 15 hours today, you worked 15 hours yesterday, we're in the same work week, you work 10 hours tomorrow, and then you're done for the week. An employer can schedule the number of hours in a work week to avoid overtime, even if that causes a lot of morale problems and chaos for the employees. That is legal. Comp time in lieu of overtime payment in the private sector is not legal.
Yeah, in the example that I gave of coaches, we would not be permitted to say you worked a doubleheader playoffs, so you worked 80 hours over the last 2 weeks. We'll let you take the following week off to accommodate for that because it's not in the same work week. So our work week starts at midnight on Friday, and by 11:59 the following Friday night, any comp time we give has to happen in that same week because we're a private institution. So we cannot use comp time for later out of season time.
Thank you very much. Moving on, Representative Grove.
Thank you, Chairman. The first panel was, I'll call it the government panel. Secretary of Labor and Industry and Deputy Secretary is still with us today. I want to attribute this to one of them, but during that panel about this regulation said, and I'll paraphrase, they, private sector businesses, will just have to adjust their business model for our rules. As individuals in the business community, what does that say about the Pennsylvania business climate? Is this a place that you want to do business that government's just going to say tough, just readjust?
If I may answer that, right now this is the first time we open with healthcare. I'm just going to use that real brief. It's a separate issue, but kind of relates. We open with healthcare for our employees. A bartender that didn't work 30 hours, a server that her whole family joined our system. She worked 25 hours a week. Anyway, zero deductible, great health care. This took 4 months of my time to get health care for my employees this year. And, it just now that employees are 30 hours right now, and because we physically just couldn't offer the same health care like we used to everybody, the rates go up every year. 75% rate is just not viable for my employees or my business. Thankfully, National Restaurant Association got involved, and we got a plan through them. To answer your specific question here about this mandate, is there's other companies near me that decided they have a kitchen manager, a general manager, and a front of the house manager. So instead of my company training up line lead, sous chef, executive chef, front of the house manager, general manager, we're a brewer. We have 6 managers every day. Everybody gets vacation. Everybody works 40 hours, 45 hours if they choose. It would definitely I'd have to change I couldn't afford the increase. I'd have to change our business model to be more like the folks around me because I can't raise my menu prices.
So in effect, you're actually letting people go or downgrading them
First
to
time this
salary.
was mentioned 2 years ago, it already happened. Unfortunately, we didn't replace 3 positions.
So, for me, besides Pocono Whitewater and Skirmish, I attempted to open another small company to work with the skirmish numbers. Our paintball numbers in general have been going down, which has meant less and less hires for us every year. And yes, the regulatory environment in Pennsylvania was hostile enough that after spending a ton of money putting me back into debt, we walked away from the entire project. It was it was going to open up. We were going to have about 10 full-time non-seasonal, which in my area is very, very important. I mean, everyone in basically the whole county is a seasonal employee, whether they're a ski area, whether they're a rafting company, paintball, whatever. And the regulatory environment and the amount of red tape that we had to jump over, we determined that it just didn't work out. The numbers simply don't work. If you have too many regulations, or most importantly to this meeting today, regulations that do not match.
Perspective as well. I can yell if that's.
No, you
I'm
have
good
to
at that
record
too.
it. Yeah.
So, I was delighted to hear, that's what doesn't work. I was delighted to hear the Deputy Secretary indicate they're talking with the department. That's really key, but adjusting business model in the nonprofit environment, and particularly in a cost reimbursed environment, you've got cost and expense, right? Well, we can't raise our costs without a full partnership with the department, and that kind of a structure and a system does not exist in an ongoing systematized fashion. And we can't reduce expense because we are governed by regulation that require the amount of individuals that we employ to care for those children that we love. And we wouldn't even if we could, because that would compromise quality of care to a point where we weren't doing our job. So that nonprofit balance in this is really very complex, and business model adjustment then is left only to things like fundraising, ancillary business product line development, which then puts you in the position of talking about unrelated business income and potentially compromising your nonprofit status. So it's extraordinarily complex, and it's really not something the nonprofit environment can entertain. We have to make things work with the rate reimbursement structure that exists, and that's why it was wonderful to hear that there are conversations with the department, but it would be wonderful if there was a special category of your discussions around nonprofit. I don't mean to throw my for-profit friends here under the bus at all. I understand you've got your own unique complexities, but the flexibility in the nonprofit environment really does not exist.
Yeah, and in terms of for us changing our business model, again, it's reducing student services and fundamentally also changing the way athletics and sports are played at the college level in Pennsylvania. We will have teams canceling in the middle of doubleheaders because there's no overtime left in the budget, so they have to come home. They're not allowed to go to the hospital to visit injured students. They're not allowed to go on recruiting trips and go out to dinner with the family because there's no overtime in the budget to pay for that. So in terms of how our business model will change, we have trouble even wrapping our brain around what that would look like in higher education because of the sort of unique nature of the services we provide to students.
Thank you. Moving on, Representative Kruger-Branicki.
Thank you, Mr. Chairman, and thank you, each of you, for your testimony today. I've got a question specifically for Ms. Hayes and Ms. Yaw, the nonprofit service providers. I was an executive director before I ran for office, so I understand the challenges of managing staff and working with tight budgets. And I'm curious, one of the things, there was a robust conversation with the Secretary and Deputy Secretary about the impact on nonprofit service providers. And I've met with direct service workers in my office and heard the challenges of doing work that they love with clients that they care for, and yet not being able to sustain their own families on the low wages that they're making. As the Secretary said, there are conversations ongoing with DHS about this. I sit on the Appropriations Committee, and in budget hearings every year we push for increased payment because we know that you're doing more with less, and that the folks that you employ who are the direct service providers for vulnerable individuals need to be able to make a living wage. What would your recommendations be for those conversations with DHS that the department is having right now?
I'll jump in and then hand it off to you. We, for a very long time, we have been interested in working with the legislature and the department on a structured increase environment that would make rate schedules predictable. And so you've heard our other panelists today talk about the issue of budgeting and being able to understand how to manage these kinds of cost increases year over year because they can do some prediction of what they can sell their product for. As a nonprofit provider, we are hampered in our ability to do that because without a predictable rate increase structure that's tied directly to economic measures, it's very, very hard for us to get to a place where we can do that kind of effective budgeting. And so we would ask for a very close partnership with the legislature and the department that would make reimbursement rate increases predictable and related to economic indicators of expense. and annualized. And we do understand the complexities that you go through in your budgeting processes. But the work of the nonprofit field is really to wrap our arms around and pick up incredibly vulnerable folks. And it's very hard to budget effectively and to make investment in staff. And that is what we would like to do. We would like to make investments in our staff so our hourly staff are able to take advantage of things like STAP programs for continuing education, to go from being direct care workers to being managers to being social workers. That's what they want to do. That's what we want for them. But budgeting toward that end is very hard without sort of a predictable, interrelated partnership that allows us to budget year-over-year increases, because costs are going to go up every year, regardless of whether our rates do or not.
Well, and with that, I think that the conversation has to go beyond DHS. Many of our clients receive services that are funded through Medicaid. And so managed care organizations have to be a part of this dialogue and be on board, as well as DHS and counties through which DHS funding is funneled. Certainly it would be great if we could get commitments on the front end rather than in arrears, even as it's considered now when you present last year's expenses and they consider whether or not, if they're even going to entertain the conversation, whether or not they can do anything with your rates. So, the goal would be to get ahead of this and to have all of these parties at the table, because the funding usually comes from some combination of these sources.
Thank you.
May I make one quick comment on that? I think that the issue of managed care, that was an excellent point to bring up, and my last suggestion would be to generate an understanding that managed care entities have become almost quasi-governmental entities in the way that they're managing funding. And so I think that a greater engagement with the legislature and responsibility to report back to the legislature around rate setting processes would
Thank you. Well, fortunately, managed care has nothing to do with the Labor and Industry Committee. So we'll move on to Representative Kiefer.
Thank you, Chairman, and thank you, guests, for attending today. Mr. McCafferty, a question for you. As a small business owner, would you classify yourself as middle income, high income, low income?
I'd say middle income. Yeah.
Middle income. And that's where I believe I come from a family of small businesses, and I believe that's where we're at too. So when we're talking about middle income, you're trying, most small businesses are trying to keep their head above water, keep everybody, and your employees are your backbone. So if you're a bad employer, you're surely going to, especially in today's employment climate. So how do you navigate all of these rules and regulations as a small business owner? I mean, trying to run the business and then determine each of these levels of salaried employees if they meet that duties test. How do you determine that and navigate those on a day-to-day basis?
Well, we opened in 2005 with 52 employees, and I was washing dishes when the dishwasher called off, and I'll do anything if it makes sense and needs done. But we slowly got management, and we slowly, did the duties test. I took some at the time it was classroom offered by Manufacturing Business Association, but I tried to get as much HR as I could because I wasn't familiar with any of that. Initially I wanted to make sure that we paid better than the local restaurants in our area, just because I wanted to, and because I wanted to, maintain the best people I got in. Especially, I just wanted to move from washing dishes. So it starts there, and you have to have a competitive rate. And now it's salary.com, Glassdoor. I know my employees are looking. I know that I'm looking because I welcome that source of information, actually. So that's where the rates, like the 48,000 threshold they're mentioning, is actually like lower on the executive chef arena, like for starting as an executive chef. So, we have folks that are making 52, 55. We've had employees making 81, and thankfully they're able to be paid that. But they had the experience level to make that salary level. And that's how business is structured, actually. So, you just have to, you just don't walk into executive chef pay. You actually learn how to do all the stations and
right. And so and that's basic economics as well. So as you have a store that's producing $100,000, you look at a salary, it's commensurate with that. So a salary that's commensurate with that is usually around $35,000 for a store that produces that. So you're mandated now to take that up to $48,000 or $50,000, whatever that may be. It's just not sustainable. So we are setting up small businesses like yours to fail. We're putting you below that benchmark. You're always going to be fighting to keep your head above water.
Again, it goes back to that 6% that we live on in our industry. So it's not that we don't want to do it. It's just that literally, the math of it doesn't work. Our lowest salaried person right now is just a recent, from line cook to line lead, and that's $30,000. So that's $14.40 an hour. So that's still in the industry. Anywhere from, there's people out there paying minimum wage, I'm sure, but really that's really rare. You have to be competitive with your wages right now. It's hard to attract employees.
Right. I've been hearing that across the board. Thank you.
Thank you, Representative Maloney.
Thank you, Mr. Chairman. I didn't really plan on any questions. Very good, interesting conversation here. I want to thank everybody for testifying today, but this second panel, I believe, has sparked something that I believe paints a better picture for what the environment is like and the challenges for small business. I came from small business. I also was forced into really considering office because of the regulatory climate that gets handed down on so many different levels. I used to have a comment many times, frustrated when I came home at night. I used to say to my wife, for some reason or other, when you're in business for yourself, people think you have a tree back at home that you pull $100 bills off of. And when I think of the restaurant business, which is an extremely difficult business, very few banks will finance restaurants for that reason. I opened up a health club business years ago with somebody when I was a competitive bodybuilder. It was the largest growing industry in America and the fastest closing industry because of the challenges that it took every single day to bring that dollar in the door to pay your overhead. And when I think of the monies that the small business person must try and predict, not only to come in, but what the future will hold for that $20 or that 20-year, rather, say loan to break ground on a piece of property that now your property taxes will go through the roof. And so when you think of the bigger picture with respect to, we should all know that the market drives the value. And when we think of the 8 or 15 hamburgers or whatever that might be that it takes to make up that loss, I don't know how we continue to hand down not just the unfunded mandates that we hear, but a small business does not have endowments. Those endowments come from your worth. They come from you leveling your household or any value that you may have on your business for the bank to say, okay, we'll let you borrow more money. And so I think what you guys did today was a great example of the challenges that the small business has. The regulatory climate in Pennsylvania is disgraceful. There's really no other way to put it. And I don't know of any employer, including myself and everybody I know, who doesn't want to give good compensation for good service. But to say that one classification requires this, when in fact, how many times do you take bids on your kitchen renovation and you don't even have any consideration as to what those employees or employers are doing? You just look at the bottom line. And that's the challenges that I appreciate that you folks brought forward today. And it's very interesting that a government agency of any kind can just say, no, you shall do this. I think you saw my passion. Thank you, Mr. Chairman.
Thank you, Representative Maloney. Moving on to Representative Nielsen.
Thank you, Mr. Chairman, and I'll make it real quick. Representative Brannigan hit it on the head. We've been trying to do an increase on the rate adjustment for years up here, and we get fought every time, so we understand those struggles, and we also understand the little bit you can pay the workers that are taking care of the people with special needs that need that special attention. So we actually are here every year trying to get that during a budget, and hopefully one day we'll be able to do that. Mr. McCaffrey, hats off to you. From what it sounds like that you put through today is, you know, you're paying your people all above minimum wage. You're giving your people health care. I always say there's three different types of employers. There's the union, the non-union, and the non-human. Regulations like this are going after the non-human employers that have to be pushed and shoved a little bit to do it. I have 5 boys, all played sports. Still playing sports. They go to Catholic school right now, and their coaches get stipends down there unless they're full-time employees. And we also looked at, I mean, a simple Google search on the salaries of your institution. I'm not going to put it on the record, but they're pretty high. They're pretty high. So the 22 coaches that you might be underpaying, your average salary is way above $50,000. Your president makes a whole lot of money. And that's according to the Glassdoor. Like you said, your employees are looking. I mean, that's just a quick search. I want to point that out. And in closing, Mr. Chairman, I'd like to give a shout out to a former Secretary of Labor that's in the audience today, Mr. Tom Foley, who's being nice and quiet back there. And because he did some great work during his tenure as Secretary of Labor, and I think he ought to be applauded for it. Thank you, Chairman.
Thank you. Any one would like to respond? Since you're mentioned, you're welcome to respond if you like.
Yeah, no, I'm happy to. I would just suggest, I think probably the salaries for the coaches that you're finding are our head coaches. And I just wanted to make clear, too, that the category of employees I'm talking about isn't just particular to Mercyhurst assistant coaches. It is across the state at public schools. Assistant coaches, my suspicion is our average is probably in line with a lot of other schools. And for our school, it is definitely under the threshold. I suspect we don't have more than a handful of assistant coaches that make currently over the threshold. So
yeah, I think that's why they did the
classification issue.
I think that's why they did the season stipends, because it is a seasonal job. And I think that's why they do the season stipend and bonuses. At least that's how they do it in Philadelphia and the region down there. No matter what college, what coach, if they're not full-time employees, that's what they get. They get that like almost like a consultant you're bringing in, and they're only for that season. Unless they're teachers, where they get a
for high school, are you talking
for
about?
High school and some of the colleges, yes.
Yeah, well, for colleges, our assistant coaches, and it's common across the state, all colleges and universities, assistant coaches are full-time employees. They work 12 months. They have the season, and then they have recruiting responsibilities. Our assistant coaches, 95% of them are full-time 12-month employees, and we don't have a mechanism currently under the Pennsylvania law to pay them fluctuating work. So I guess my larger point is the Department of Labor fact sheet on academic counselors, admissions representatives, and also assistant coaches was extraordinarily helpful in allowing us to have a concrete exemption category to put these folks in. The Pennsylvania state law does not have any equally clear exemption, and I think it goes back to the point about the compliance trap. So I am not necessarily advocating against threshold increases. Certainly there are costs to us to doing that we either have to pass on or things we have to cut for students. We're asking for the clarification in terms of being able to clearly exempt them so that we can comply.
Maybe Kathy can address that, if you could, Kathy, real quick. Can that be done under regulation, or would that have to be a law change?
Well, The problem right now is that the federal law states that the employer must comply with the law that is better for the employee. So if Pennsylvania raises its thresholds above the federal, then everyone doing business in Pennsylvania has to comply with the state. And that can be done by regulation for these overtime categories.
Okay.
There
So-
are other things that can only be done by statute, but this.
So that's a great point she brought up. Then that's something we have to look at as we go through this regulation process. That's great, and I appreciate that.
That's my point about it. Used to be a clean divide, but it isn't a clean
anymore.
divide any longer. So, for example, I am going through things where I very much appreciate home care at the moment. And even if we wanted to change something for home care at the state level, we could be setting up another compliance trap at the federal level. So we've got to be very careful. If you are going to adopt the federal regulations, and I applaud the department for trying to comply, why not adopt them by reference so that we adopt all the regulatory guidance that goes along with it, the sort of thing that we're talking about?
And well, I think that's why the chairman called for this hearing, because this is a complicated issue that we all need to look into, and hopefully we'll get through this soon. Thank you, Chairman.
Thank you. And finally, Representative Dush, and just to remind you, you're the only thing standing between us and our lunch break.
You did that on purpose, Chairman.
I did that on purpose. Sorry, Chris.
No, you're not. First of all, I want to start with the Secretary brought up the 2.7% a year over the last 15 or 20 years. The only place I've seen that was in the public sector. I went back, pay range 4 for SEIU union employees went from 26,414 to 33,429, which that amounts to about 2.7 a year. That's for staying in the starting range. If that same employee did not get a promotion, stayed in there, he's now making 44,545, and that's before the $900 million pay raise that went into effect in September of last year, or 16. The thing that gets me is we keep building, you guys all touched on it, whether it's private sector, nonprofits, public sector, is the unfunded mandates. We are creating positions in Harrisburg and other areas that are, a lot of them are make-work jobs. The data that we're collecting ends up going into, it gets stamped, it's received, put into a box, an event. When the box gets full, it gets put into a closet, and no benefit. It's happening in the public sector, it's happening in the private sector. I've got people in different departments telling me about what's happening to these forms and what's not happening with them. You guys, my DSPs that are making 8-something an hour up in my area, they're paying for that $900 million increase plus that 2.7 that happened every year for 15 years while they haven't seen it. Nationwide, for the 15 years prior to 2016, it was an $84 drop in median family income over that 15 years. In my district, it was $1,140. And we were asking those people to pay more for government. Businesses and nonprofits, the people who are actually out there taking care of our disabled people, our in-home care nursing, as well as the businesses. They've had to work and make pinch pennies in order to stay alive, while government hasn't. God bless each one of you guys. Where in the this panel, I want to thank you. Like I said, you and Chairman, I want to thank you because we'll get to lunch, but this is public, private, and nonprofits all coming together and giving an excellent example of where the bureaucracy is running amok. Thank you.
Thank you very much. I think this was a very productive hearing, and we had equal balance of time, and I want to remind you that we will be reconvening at promptly at 1:30. So you have exactly 1 hour. Anyone who's returning, which hopefully everyone up here is returning, you have 1 hour and 20 minutes. We'll see you at 1:30. This meeting is adjourned.